Hello. Today I want to talk about dying without a will, otherwise known as intestate succession. Let's start with the definition. Intestate succession involves a set of laws that determines who will receive your property if you die without a will. Remember that this does not include assets transferred automatically by law, for example, joint tenancy accounts, life insurance, or retirement accounts. Intestate succession requires us to first determine whether the decedent, the person who died, was married or not. If they were married or in a registered domestic partnership, we first have to understand the concepts of community property and separate property. Community property is the income that you earned during your marriage or registered domestic partnership, and property that you bought during your marriage or partnership. It's considered owned half by you and half by your registered domestic partner or spouse. Separate property is the property that you own prior to getting married or entering into your registered domestic partnership. It also includes property that you received by gift or inheritance and the income from separate property. Say, for example, you had real estate before getting married. The rent from that real estate would be considered your separate property. If you die while you're married or in a registered domestic partnership, all of your community property would go to your surviving spouse or your registered domestic partner. All, one half or a third of your separate property would go to your surviving spouse, and the rest would go to your family depending on who survives you. For example, if you had children or grandchildren, parents, sisters, brothers, nieces, nephews, or other close relatives. If you're not married or in a registered domestic partnership at the time of your death, or you're widowed, all of your property would get distributed as follows. First, it would go to your descendants. These would include children, grandchildren, and so on. If you didn't have any living descendants, it would go to your parents. And if you didn't have any living parents, it would go to your siblings. If you didn't have any living siblings, it would then go to your grandparents, or the descendants of your grandparents. Next, it would go to the descendants of your predeceased spouse or your domestic partner. If none of those people are alive, it would go to your next of kin, which would basically mean the closest relative that you have in your family tree. If you didn't have any living next of kin, it would go to the parents of the predeceased spouse or registered domestic partner, or their descendants. Finally, if you had no living relatives and none of the people described in this list, your property would go to the state of California. Here are some things you might want to think about. 1. Are there potentially irresponsible people that would receive part of your property if you died? What if they had a drug problem or money problems? Would you want them receiving part of your assets? 2. Are there young children that might receive some of your assets? Are they really ready to receive the money or other property that you might leave behind? 3. Maybe there are people who already have their wealth and don't really need any more money from you. Are there charities or other organizations you might want to leave money to? What if some of your beneficiaries are receiving government aid? Do you know what impact your gift to them might have on their aid? Maybe they don't want to lose their benefits. 5. Are there beneficiaries who you aren't close to or maybe you don't even know? Would you want them receiving part of your assets? 6. What are the tax consequences involved in the way you're leaving your money behind? Have you thought about how to plan that in an optimal way? A proper estate plan can help you deal with all these contingencies, so I recommend that you seek advice from a qualified estate planning attorney. Thank you.